That's correct, Your Honor.
Madam Interpreter, we're good to go, but thank you for calling in.
Thank you.
Oh, we just lost everyone.
Pretty off.
Are we still on? I'm hearing things. All right, Jail, are you still able to hear us? We had some sort of glitch on our end.
Yes, Your Honor, and we can see you.
Cool. Hello, can I get your name? All right, ma'am, we're seeing you this evening because you've been picked up on some charges out of Tucson City Court. It looks like you have a case pending where you've been charged with 1 count of criminal trespass in the first degree. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, though not necessarily at court expense. You have the right to be present for all court proceedings. However, if you fail to come to court, then a warrant will issue for your arrest, and those hearings can happen without you. Now, if you are convicted and you cannot be sentenced within 90 days because of your failure to come to court, then you could also lose your right to a direct appeal. Whoever's talking in the background, could you mute or keep it down? Are you still able to hear me, ma'am? Okay, just wanted to make sure. So what we're going to do tonight is we're going to talk about your release conditions and your next court date. I am going to enter not guilties on your behalf to this charge. I'm also going to appoint the City Public Defender's Office to represent you. Now, I see that you are currently being held on a separate matter. So what I'm going to do is I'm going to hold you on a $250 cash or secured bond in this case. That'll start getting you some time credit for this case. As conditions of your release, you're not to possess or consume any alcohol or illegal drugs, possess no firearms or weapons, have no contact with any listed victims, their residences or their workplaces. And your next court date, if you are still in custody, will be a video review hearing on July the 11th at 1:45 in the afternoon. If you're out of custody, it will be August 4th at 9 o'clock in the morning, and you'll get paperwork that has all this information. Now, ma'am, if you're released, you need to make your court dates or a warrant will issue. Do you understand? All right, ma'am, you're excused. Here, and you hold on to these.
Your Honor, Olson, McCallie, Jacob, refused.
Okay, we'll go ahead and bump until the morning. Let me just find him real quick. You said Mikhail Olson?
Yes, Your Honor. As well as Prudent Angela.
Pruitt?
Yes.
Okay, I will move both of those then. Pruitt. So I pre-filled out one of the pages. You want me to just fill in through it? Yeah, okay. Hello, sir. Give me 1 second. I'm just finishing up some paperwork. Right, sir. Can I get your name?
Samuel Robert Bruce, Your Honor.
Okay. And do we have county attorney and public defender here?
I believe. I believe.
Yes, Judge, I'm here. What was the last name of the matter?
Truth. Just give us 1 second, Mr. Bruce. I want to make sure, since one of the cases is a felony, that the public defender's here in case you have any questions.
Roger that, Your Honor.
You guys looking for me?
Hello, are you ready?
Yes, Your Honor.
All right, sir, can I get your full name, please?
Samuel Robert Bruce, Your Honor.
All right, sir, we're seeing you this evening because it looks like you have a couple of different cases. You have something that's pending something in front of Pima County Justice Court. However, you also have some new felony charges as well. Defense, would you like me to waive reading?
Sure.
All right, sir, so we're going to start with your felony matter first. Now, you do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and I'm going to appoint the public defender's office to represent you. You have an attorney seated beside you if you have any questions during the proceeding this evening. We're going to be talking about your release conditions and your next court dates. Now, I've read everything presented to me, including the probable cause information, the pretrial services workup, and I see that the state is asking for a $15,000 bond. State, did you wish to be heard any further?
Judge, this case is particularly disturbing. There are a veterinarian reported that a cat that Mr. Bruce had dropped off at the veterinarian's office had a number of serious injuries to it, including hemorrhages to his eyes, a broken jaw, claws that had appeared to have been taken out. There were also a number of internet searches found on Mr. Bruce's phone that indicated that he was the one that actually injured the animal, including photos of a claw that appears to have been a bloody claw taken out, removed from the cat's paw, and certain internet searches suggesting, such as how to fix a cat's broken jaw, or what is this that I've taken a picture of, and it's in fact a picture of a removed claw. So this is a particularly disturbing case, Judge. We would just urge that any conditions of release include that Mr. Bruce is not to have contact with any animals whatsoever. Thank you.
Defense?
Judge, 1 second. I'm having computer issues, so I'm trying to pull up the services right now.
That's fine.
Apologize, Your Honor. It decided to lock me out of the pretrial services. I was going to try to use the other computer. Let me reset right here.
So we've got a bit of a longer calendar. Jail, would we be able to move on to some of the misdemeanor folks to
I'll do it right now.
So, Mr. Bruce, what we're going to do is we're going to come back to your case. I want the attorney seated next to you to have a chance to look at the pretrial services report. So we'll get right back to you, okay?
Roger that, Your Honor.
And while we've got a little bit of a lull, who do I have for the state and for defense tonight?
Judge, it's for the state, it's Peter Raptis.
And good evening, Your Honor. My name's Curtis Fisher. I'm defense for Mr. Augustine Godoy.
And then Jeremy Zarzicki for the public defender's office.
All right, thank you all.
Vanessa, have a seat right here, Vanessa.
Hi, can I get your name?
Mendoza Vanessa.
All right, ma'am, we are seeing you this evening because it looks like you've got some cases pending in Pima County Justice Court. It looks like you also have a case pending in Marana City Court. We're going to talk about your release conditions and your next court dates and all of these. First and foremost, let me go over your rights. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and as we go through your cases, I'll let you know who's getting appointed to each case. Now we're going to start with your Marana City Court case. And in that one, you were charged with 1 count of possession of drug paraphernalia. Now, based on the nature of your charges and the history in that case, I am going to release you on your promise to appear. And your next court date is going to be July 30th at 10 o'clock in the morning. You're not to possess any alcohol or illegal drugs, and you're not to have any contact with any incident locations. You will get paperwork for Marana that gives you information on where to go and when your court date is. Now, in your justice court cases, you have 3 different matters pending. You have one from 2019, one from 2023, and one from 2021. In the 2019 case, you were charged with 1 count of misdemeanor shoplifting. In the 2021 case, you were charged with misdemeanor shoplifting, criminal trespass in the 2nd degree, as well as a failure to appear. And in the 2023 case, you were charged with assault, knowingly causing injury. In all of these cases, warrants were issued back on June 3rd of 2025. Now, what I'm going to do in these cases, ma'am, I am going to appoint Robin Auld to represent you. Again, you'll get paperwork that has his contact information on it. I am going to order you be held on a $100 cash or secured bond. That's the amount listed in each of these warrants. I will make that bond concurrent between all 3 of your justice court cases. And your next court date will be July the 3rd at 1 o'clock in the afternoon. Now, ma'am, as conditions of your release, you're not to possess any alcohol or illegal drugs, have no contact with any victims or incident locations. You need to make sure you make your court dates. If you don't, then warrants will issue for your arrest. Do you understand?
Yes.
All right, you're excused. Hello, can I get your name?
Clifton Morse.
All right, sir, we are seeing you this evening because you've been arrested on some misdemeanor charges out of Green Valley Justice Court. You've been charged with 1 count of domestic violence disorderly conduct and 1 count of domestic violence criminal damage. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, though not necessarily at court expense. We're going to talk about your release conditions in your next court date. Now, based on my review of everything, I am going to release you on your promise to appear. However, there are going to be some conditions. Pretrial services was not able to reach the victim in this case, so I don't have their position as to whether or not they're okay with having contact. So what I'm going to do at this point is I am going to order no contact, either with the victim or their residence or workplace. You're not to commit any acts of domestic violence. You're not to possess any alcohol, illegal drugs, firearms, or weapons. Now, sir, do you have a separate place that you can live?
Yes.
All right. Do you need to return to that residence for any reason?
No, I don't.
All right. So your next court date is going to be an arraignment hearing, and that will be July the 10th at 8:30 in the morning. Sir, you need to make sure you make your court dates. If you don't, then a warrant will issue for your arrest. Do you understand?
July 10th at 8:30, right?
Yes, sir. And you'll get paperwork with that information.
Okay.
All right, sir, you're excused. Hello, can I get your name?
Miles.
Sorry, you said Karen? Okay, so we're seeing you this evening because you have a number of cases pending in Tucson City Court. It looks like you have 10 cases currently open. Between all of those, you were originally charged with criminal trespass in the 3rd degree, possession of drug paraphernalia, disorderly conduct, shoplifting, assault, domestic violence, criminal damage, domestic violence, and it looks like there's also a pending petition to revoke your probation. So, sir, you do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and I'm appointing the City Public Defender's Office to represent you. You have the right to be present for all court proceedings. However, if you fail to come to court, then a warrant will issue for your arrest, and those hearings will happen without you. Now, if you are convicted and you cannot be sentenced within 90 days because of your failure to come to court, then you could also lose your right to a direct appeal. Now, with regards to the probation matter, it looks like a petition to revoke was filed back in March of 2025, alleging that you failed to complete an intake, both for probation, substance abuse evaluation intake and treatment, as well as domestic violence intake and treatment. Now, sir, I'm going to order that you be held on $1,000 cash or secured bond. You're not to possess or consume any alcohol or illegal drugs, commit no acts of domestic violence, possess no firearms or weapons. You're also not to have any contact with any victims, residences of the victims, workplaces, or incident locations. Your next court date will be a video review hearing, and that will be on July the 11th, 2025 at 1:45 in the afternoon. If you're released from custody, sir, then you need to get down to Tucson City Court on July 22nd, 2025 at 1:30 in the afternoon. If I didn't mention it already, you are going to have the City Public Defender's Office appointed to represent you. Now, sir, if you're released, these matters are not going to go away. You need to get these taken care of with Tucson City Court. If you don't, then a warrant will issue for your arrest. Do you understand? Sir, did you hear anything that I just said? Mr. Zarzicki, could you double check and see if he's awake, please? Sir, did you hear anything that we just talked about?
Yes, ma'am. Sorry.
All right, what did I say? You want me to go through it again?
Yes, please. I'm sorry.
Sir, you have a number of cases pending in Tucson City Court. You've been charged with a number of different types of felonies, the high points of which are shoplifting, criminal damage, assault, as well as possession of drug paraphernalia. There's also a criminal damage and some probation revocations as well. You have the right to be present for all court proceedings. However, if you fail to come to court, then warrants will issue for your arrest and those hearings will happen without you. You also have the right to an attorney, and the City Public Defender's Office is appointed to represent you. Now, if you fail to come to court,
Your Honor,
I'm sorry,
hello?
who is this?
It's Richard Hopkins. I had a terrible time trying to get on. I was set up on the computer. I couldn't get through, and I finally got through on this number. I'm sorry to interrupt you, but I have a client named Samuel Bruce.
Samuel Bruce? All right, sir.
Samuel Bruce is my...
Well, sir, we will go ahead and get... Sir, let me finish. So
okay,
I didn't know
if he... Okay, I'm sorry about this. I'm sorry to interrupt you, but I just... I just got on and I had a real tough time, Judge.
Nope, that's understandable. I think everybody's having an issue with tech tonight. So, Mr. Bach, we will go ahead and get to Mr. Bruce here in a second. Have you had a chance to look at the pretrial services report?
Well, I'm at my computer, so I haven't seen the pretrial service report.
Okay, so we'll go ahead and get to you in a second. Right now, I'm talking to an individual about a different hearing. So, Mr. Miles, wake up. Are you capable of actually doing this hearing tonight, sir?
Yes, yes, yes.
Okay, sir. You are going to get paperwork with all this information. When you come to court, sir, I do recommend that you do your level best to actually pay attention to what the court is saying, because it is something that directly affects your life.
I'm sorry, Your Honor.
You are being held on $1,000 cash or secured bond. Your next court dates are contained in the paperwork that you will receive, as well as information as to the charges and your release conditions. You're excused.
Hold on. I'm also handing him a card with my contact information.
Thank you, Mr. Zarzinski. So, Mr. Bach, let me get back to you. So there was a pretrial services report. Was that sent to you? Have you had a chance to look at that?
No, I haven't even filed a notice of appearance. I found out about his hearing later today, and I will be filing a notice of appearance on the paperwork, but I can't do that until Monday because I don't have a secretary tomorrow, and obviously Friday's a holiday.
All right, sir. Let me figure out what we're going to do with that case. I have another individual in front of me. So, Mr. Bach, if you hit *6, that will mute you. And then when we get back to Mr. Bruce's hearing, then you will hit *6 on your phone again to unmute. So, sir,
Okay.
over there at the you should what, sir?
Hit *6 now and then.
Yes, sir. *6. All right, over at the jail, I'm sorry for the wait. Can I get your name, please?
Jesse Stover.
All right, Mr. Stober, we're seeing you because you have a number of different cases pending in Tucson City Court where warrants have issued for your arrest. In total, you have 9 cases pending stemming from charges in, looks like 2019 is the oldest. You also have some from 2020, 2021, and 2022. Between all those cases, sir, you've been charged with, let's see, solicitation, possession of drug paraphernalia, criminal trespass in the 3rd degree, obstruction or refusal, as well as multiple failures to appear. A warrant was issued back for your arrest on February 25th of 2025. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and I'm appointing the public defender's office to represent you. You have the right to be present for all court proceedings. However, if you fail to come to court, then a warrant will issue for your arrest, and those hearings will happen without you. Now, if you are convicted and you cannot be sentenced within 90 days because of your failure to come to court, then you could also lose your right to a direct appeal. I'm going to enter not guilties on your behalf for any charges that you have not already been arraigned on. I am going to order that you be held on the $250 cash amount that's listed in the warrants. As conditions of your release, you're not to possess or consume any alcohol or illegal drugs, have no contact with any listed victims or any of the incident locations. Your next court date will be a video review hearing on July the 11th at 1:45 in the afternoon. If you are released from custody, then you need to get down to Tucson City Court on July 31st at 9 o'clock in the morning. Sir, you will get paperwork with all of this information on it. However, you need to take care of these matters if you're released. If you don't go to court, then a warrant will issue for your arrest. Do you understand? All right, sir, you're excused.
Thompson.
I don't know where it went. I think it might be. Yeah. Yeah. Sir, can I get your name?
Cody Ray Thompson.
All right, sir, we're seeing you because you have a case pending in Tucson City Court where you've been charged with 1 count of criminal trespass in the 3rd degree as well as 1 count of disorderly conduct. Those are both alleged to be domestic violence offenses. We're going to talk about your release conditions in your next court date. Now, you do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, though not necessarily at court expense. You have the right to be present for all court proceedings. However, if you fail to come to court, then a warrant will issue for your arrest, and those hearings can happen without you. Now, in the event you are convicted, if you cannot be sentenced within 90 days because of your failure to come to court, then you could also lose your right to a direct appeal. Now, I am going to enter not guilties on your behalf to these alleged charges. I'm just checking something in your pretrial services report. Now, I am going to release you on your promise to appear. However, as conditions of your release, you are not to have any contact with the alleged victim. That's Fernando Gonzalez.
Yes.
You are also not to have any contact with his residence or his workplace. Additionally, you're not to possess any firearms or weapons. You're not to commit any acts of domestic violence, and you're not to possess or consume any alcoholic beverages. Your next court date, sir, will be on August the 1st at 9:30 in the morning. Sir, if you don't make that court date, a warrant will issue for your arrest. Do you understand?
Yes.
All right, sir, you're excused.
Would you like to see Bruce?
Yeah, we can go ahead and do Mr. Bruce next. So, Mr. Bach, if you want to hit *6 to unmute yourself. Now, Mr. Bach, before we go back on the record, well, let me go back on the record on this case. So this is Mr. Bruce. We're back on for this case. We did have another attorney who called in. Mr. Bach, we also have a public defender, Mr. Zarzycki, who is over at the jail. I don't know if Mr. Zarzycki has had a chance to be able to pull up the pretrial services report on his end. Mr. Bach, are you comfortable standing in for the initial appearance tonight, or would you prefer to have the public defender handle that? And I note that you're present for the record. You have to hit *6, sir.
Hello?
Hello? Yep, that worked.
No breaks for years.
Can you hear me?
Yes, we can hear you.
Okay, thank you, Judge.
So I know, Mr. Bach, you indicated that you would not be able to file a formal notice of appearance until probably tomorrow at the earliest. Are you comfortable proceeding with the? Are you comfortable with proceeding?
Yes, I'll file it on Monday. I have no secretary tomorrow, and Friday's a holiday, but I am out of the court. I will file it on Monday. I just need the case number, the justice court number.
So the justice court number that I have. I am showing CR 25-008767FE.
Okay, so I have 00 after 2025. Did you say 30, Your Honor?
2 zeros, 8767.
8. Okay, so I have 008767FE.
Yes, sir.
Okay, I'm prepared to do the initial appearance on
Okay.
behalf of Mr. Bruce with your permission.
Okay. So, Mr. Bruce, what I've been told is that the attorney who's calling in right now has indicated that he's going to file a notice of appearance in your case. He's going to go ahead and still stand in this evening to do the initial appearance. Now, I indicated earlier on the record that I had read the pretrial services report as well as the information contained in the probable cause statement, and that the state was recommending a $15,000 bond. Mr. Raptis, I'm going to ask that you go ahead and make your recommendation again since we've had a change in counsel.
Yes, Judge. Just 1 minute. So the state is recommending a $15,000 bond. Judge, this case is a very disturbing fact pattern where Mr. Bruce was put in charge of caring for caring for a cat while its owner was out of town. Mr. Bruce brought the cat into a veterinarian. The veterinarian reported to police that this cat had extensive injuries, including a hemorrhaged eye, swollen paws, significant bruising to its throat and mouth, signs of strangulation, and that was missing 3 of its claws. When there was a search done of Mr. Bruce's phone, they found pictures of one of the bloody claws that were removed from the cat, as well as internet searches indicating that he was aware and may have even, likely caused these injuries to the cat, such as, one search was how to fix how to mend a broken jaws. It's something to that effect. So there's certainly a lot of evidence in this case against Mr. Bruce, and we would ask that he's also pending an aggravated assault domestic violence charge in CR 2024-3456. So for all these reasons, Judge, we're asking for a $15,000 bond, and we're urging that any conditions of release require that he have no contact with any animals. Thank you.
Mr. Bach, do you have any recommendation?
Yes, Judge. First of all, he is in custody on a petition to revoke. And I spoke to his probation officer earlier today, and he indicated that the petition to revoke is going to be amended. Apparently, he knew about the fact that there were going to be new charges that were going to be leveled against Mr. Bruce sometime today. He is a citizen. He was on probation for, I believe, a class 5 felony. He has a residence in Tucson. This case needs to be thoroughly investigated. The pet owner, I believe, is supportive of my client, and I think there are explanations that can be made. He's presumed innocent. Obviously, at this point in time, I think $15,000 is clearly excessive. I would ask that he be released to pretrial services. Again, he has his petition to revoke, which needs to be handled, and he's in custody on that. He has a hearing on that on July the 9th in front of Judge McGinley. If probation, which they indicated to me, is going to file an amended petition to revoke, that's going to have to be dealt with. So I would ask that he be released to pretrial services. He has no favors to appear.
All right. After considering everything, and since we had a little extra time, I did look into the probation violation matter as well. I do note that the probation matter that he's currently pending the petition to revoke on is a domestic violence offense where the underlying facts were pretty concerning. And there's a lot of research out there that talks about the links between alleged animal abuse and alleged domestic violence, and that they often go hand to hand in terms of presenting risks to certain populations and to society. Given that he's on probation, given that information, and given the nature of these charges, I am going to order he be held on a $25,000 cash or secured bond. He will be supervised by pretrial services if he posts that, and he will have to comply with any monitoring or treatment directions that are given. He is not to possess any alcohol, illegal drugs, firearms, or weapons. He is not to have any contact with the victim in this case, which would be the pet's owner. He is also not to have any contact with the incident location or the pet owner's residence or place of employment. I'm further going to order that he not have any contact with any animals, and he is not allowed to reside at any location where animals are kept once he is released. His next court date will be a preliminary hearing on July the 14th at 1:30 in the afternoon. Now, there is also a justice court matter that I am showing on our docket. And counsel, Mr. Bach, Mr. Raptis, you may want to look into whether or not there is any overlap between these two cases. Based on my review, it looks like they may involve the same sheriff's report number. In that case, sir, I am going to order you be held on a $250 cash bond. I am going to appoint Mr. Bach. Would you be representing him in any justice court matter as well, or just a felony?
Now I can represent him on the justice court matter. Do you have a number on that one also, Your Honor?
I do, sir, and that is CR 25-008775.
Okay, and when is his next appearance on that?
I will give that to you all in 1 second. So let me just put down that you may be filing a notice of appearance.
Yes.
Your next court date, sir, will be an arraignment hearing, and that will be tomorrow, July 3rd at 1 o'clock in the afternoon over at Pima County Justice Court with Judge Garza. You're going to have the same types of, or same conditions of release that I imposed in the felony matter, with the only exception being you will not be on pretrial services supervision. Now, sir, if you're released from custody, you need to make sure you make all of your court dates. If you fail to make any court dates, then a warrant will issue for your arrest. You're excused. And Mr. Bach,
Hey,
Thank you, Your Honor.
thank you for coming.
Your Honor.
Hello, sir. Can I get your name?
Tegan Andrew Oldham.
All right, sir, we're seeing you this evening because you've been arrested on new felony charges. You've been charged with domestic violence, aggravated harassment. It looks like several counts of that. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and I'm appointing the legal defender's office to represent you. You have an attorney seated beside you if you have any questions this evening. Now we're going to talk about your release conditions in your next court date. I've read everything presented to me, including the pretrial services workup, the interim complaint, as well as the state's recommendation. The state is asking for a $10,000 bond. Mr. Rappis, anything further?
Judge, I would just urge that Mr. Oldham has already shown that he is not willing to comply with the court's orders. He's contacted the victim in violation of that court order, of the standing court order, approximately 6 times via the phone while he's been in custody. Thank you.
Mr. Zarzynski?
Okay. So, Your Honor, so first off, he wanted me to reassert that these were calls made from a jailhouse tablet, that it was not his tablet, that he was not the one that was making these calls. I will note that he has, obviously there is some felony history here, but largely there's an old there's the old ag assault, which he's currently got the DOC hold on, and then after that, or older, after that, so it's non-violent as far as that goes. He has his assessment on this is a 5 and a 3. He has no NVCA flag. He does obviously have housing in so much as he's going to be in custody anyway. Given the other current case, and given the fact that he has a pending DOC hold, I understand the odds of him being released are slim to none. But we would ask for a more nominal bond. I mean, frankly, with the other 2 matters pending, he's not going.
All All right, after considering everything, sir, I am going to follow the state's recommendation and order you be held on a $10,000 cash or secured bond. You will be supervised by pretrial services if you post that, and you'll need to comply with any directions they give you. You're not to commit any acts of domestic violence. You're not to possess any alcohol, illegal drugs, firearms, or weapons. You are to have no contact whatsoever in any way, shape, or form with Isabel Wilson. And sir, that means third-party contact. That means contact through social media, tablets, phone calls, letters, you name it, you can't do it. You're also not to have any contact with her residence or her workplace. Your next court date will be a preliminary hearing on July the 14th at 1:30 in the afternoon. Sir, if you bond out of custody and are released on your other matters, you need to make your court appearances or a warrant will issue for your arrest. Do you understand?
Yeah.
All right, sir, you're excused.
We'd like to know because yeah, because it sounds like yeah. We need to finish, right?
Hello, sir, can I get your name?
Pettis.
Sorry, what was that again? Pettis?
Yeah, Richard Pettis.
All right, sir, we're seeing you this evening because you have some matters pending in Tucson City Court. You have one case from 2024. Or sorry, you have 6 cases pending from 2024 and earlier. You also have a new case where you were charged with 1 count of assault. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and I'm appointing the City Public Defender's Office to represent you. You have the right to be present for all court proceedings. However, if you fail to come to court, then a warrant will issue for your arrest and those hearings will happen without you. Now, if you are convicted and you cannot be sentenced within 90 days because of your failure to come to court, then you could also lose your right to a direct appeal. Now, sir, I'm going to enter not guilties on your behalf to this new assault charge. Now, you also have those other cases I mentioned are currently set for a video review hearing on July the 8th, 2025. I am going to consolidate all your matters together. That way you have one court hearing to handle everything. So your next court date will be July the 8th at 1:45 in the afternoon. If you are released from custody, then your next court date will be July the 29th at 2 o'clock in the afternoon. I'm going to order that you be held on a $500 cash or secured bond. You are not to possess or consume any alcohol or illegal drugs, possess no firearms or weapons, and have no contact with any alleged victims, their residences, or their workplaces. Now, sir, if you're released from custody, you need to make sure you make your court dates or a warrant will issue for your arrest. Do you understand? Right, sir. You're excused. I'm just looking them up real quick, see what else his hold is. Hello, sir. Can I get your name? Sorry, did you say your last name is Aguirre? Thank you. We're having some issues with the microphones tonight, so thank you for that. Sir, we're seeing you this evening because you have been arrested for a new felony count of promoting prison contraband. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and I'm appointing the public defender's office to represent you. We're going to talk about your release conditions and your next court dates tonight. Now, I've read everything presented to me, and the state is asking for a $10,000 bond. Mr. Raptis, anything further?
Nothing further from the state, Judge.
Mr. Zarzicki?
Judge, I'll note about the only thing I have is a $10,000 bond seems excessive. I mean, quite frankly, given that he's already being held without bond on another charge, I think it's kind of immaterial what we hold him on, all things considered. But if there is some possibility that he wraps up his other cases at some point in the future, and that this is the only thing holding him, we ask for a lower bond, given that this is a case where it was even if we take the allegations as true, which obviously we're not, we can test all of them. This is a pretty standard, dorm room search that found an item that does not appear that it was being used. In any sort of assaultive way, they named it as a weapon. It's, if anything, a very unstable scheme. So with that in mind, given that he's already being held no bond, and given the nature of the charges, we'd ask for 15.
All right, sir, I am going to order that you be held on an $1,100 cash or secured bond. You will be supervised by pretrial services if you are released from custody in all of your matters. You are not to possess any alcohol, illegal drugs, firearms, or weapons. Your next court date will be a preliminary hearing on July the 14th at 1:30 in the afternoon. Now, sir, if you are released on all of your matters, then you need to make sure you make your court appearances. If you don't, then a warrant will issue. Do you understand?
Yes, ma'am.
All right, sir, you're excused.
Thank you.
Hello, sir, can I get your name?
Elliot,
All right, sir, we're seeing you this evening because you've got a few different matters pending. You have some cases in Tucson City Court that we'll talk about here in a second. You also have what looks like a new case out of Pima County Superior Court, where you have been charged with burglary in the 3rd degree. And then you have a separate case out of Pima County Superior Court where a warrant had issued. So, sir, you do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney. And starting with your felony matters, I'm going to appoint the public defender's office to represent you. Now, I've read everything presented to me. In one case, the state is asking for a $5,000 bond. In the other, they're asking for a $3,000 bond. Mr. Raptis, did you wish to be heard any further?
Nothing further, Judge.
Mr. Sarzicki?
Judge, again, sort of similar circumstances to the last case, given the various other holds he has, including his probation hold. We're not asking for release for pretrial services. I will note that the charges in this case are non-violent felony. It was essentially a jump and grab and dash at a convenience store. Given the nature of the nonviolent nature of these charges, and given the fact that he's being held without that currently on his probation rep, we would ask for a nominal bond on this case, something in the neighborhood of $1,000.
All right, sir, based on the information in front of me and the fact that it looks like there's a probation hold as well, I am going to order you be held on a $2,500 cash or secured bond. That will be in each separate case. You will be supervised by pretrial services if you post that, and you'll need to comply with any directions they give you. You're not to possess any alcohol, illegal drugs, firearms, or weapons. Have no contact with any alleged victims, their residences or workplaces, or the incident locations. Now, in terms of court dates, in your older case, I'm going to set a criminal arraignment hearing for July the 9th at 1:30 in the afternoon. And then in your newer case, I'm going to set a preliminary hearing for July 14th. And that will be at 1:30 in the afternoon. Now, in your city court matters, you have 2 cases currently pending where warrants were issued. One is both of them are from 2024. You were charged with disorderly conduct, criminal trespass in the 3rd degree, theft, possession of drug paraphernalia, 2 counts of assault, as well as some failures to appear. In addition to the rights I mentioned before, you also have the right to be present for all court proceedings. However, if you fail to come to court, then a warrant will issue for your arrest, and those hearings will happen without you. Now, if you are convicted, am I keeping you awake, sir? If you are convicted and you cannot be sentenced within 90 days because of your failure to come to court, then you could also lose your right to a direct appeal. Now, I'm going to enter not guilty on your behalf to any charges in the city court cases that you've not already been arraigned on. That may just well be the failures to appear at this point. I am going to order you be held on a $250 cash or secured bond. I'm appointing the city public defender's office to represent you. As conditions of your release, you're not to possess or consume any alcohol or illegal drugs, possess no firearms or weapons, have no contact with any alleged victims or the incident locations. Your next court date will be in front of Judge Mayhew, and that will be a video review hearing on July the 11th at 1:45 in the afternoon. If you are released from custody in all of your matters, then your next court date will be July the 29th, and that will be at 9 o'clock in the morning. Now, sir, if you are released on everything, you need to make all of your court dates. If you don't, warrants will issue for your arrest. Do you understand?
Yes.
Right, sir, you're excused. Hello, sir, can I get your name?
Augustine Godoy.
And I believe we have defense counsel on the line for Mr. Godoy.
Yes, good evening, Your Honor. Thank you. Curtis Fisher for Mr. Godoy.
Right, thank you. And you probably heard me asking Mr. Bach questions before. Were you able to get a copy of the pretrial services report?
Your Honor, I reached out to your JA and asked for the Form 4, and no information has been provided. I don't know if there's a pretrial services report or any information I can review prior to the hearing.
Is there somebody from pretrial services on the line?
Yes, Your Honor.
Would one of you be able to get a copy of at least of whatever we can get to Mr. Fisher over email, or is that not doable?
I can do that. I just need the email address to send it to.
Okay. Yeah, so the email is going to be Curtis, CURTIS, at SuzukiLawOffices.com. Suzuki is SUZUKI, and then law offices, plural.
Okay, I will get that sent right now.
Thank you very much, ma'am.
In jail, do we have somebody already there waiting? Jail, is there anybody else who's available? Is my microphone working?
It is, Your Honor. We're trying to figure out who else is.
All right. If we don't have anyone, that's fine. I just wasn't sure how long it will take to get the pretrial services to Mr. Fisher. And Mr. Fisher, if you see it come through, just holler.
Will do, Your Honor. Thank you.
Hello, sir. Can I get your name?
Angel Gomez.
All right, sir, we are seeing you this evening because you were picked up on a warrant out of a Pima County Superior Court for a felony case, in that you were charged originally with burglary in the second degree, as well as kidnapping and 2 counts of assault. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and I'm appointing the public defender's office to represent you. We're going to talk about release conditions in your next court date this evening. Now, I have read the warrant as well as the pretrial services recommendation. Mr. Raptis, did you have any recommendations?
Yes, Judge. The state's recommending a $30,000 bond. There was Mr. Gomez failed to appear at his arraignment back in June 2nd of 2022. So he's been on warrant status for over 3 years now. And so we just think that, you know, his chronic failure to appear in this case has been is problematic, and he needs to be held on a substantial bond. Thank you.
Mr. Zorzycki?
Judge, let me start by pointing out there's no felony history here whatsoever prior to these charges. Also, he was assessed relatively low on the new criminal activity scale as a 2. And despite Mr. Raptis' concerns about the misarraignment, he's only a 3 on the failure to appear scale. I also want to point out this is one of these cases that troubles me quite a bit because this was not, he was issued a summons. There's, and that summons failed. He's never personally served. The fact that we're allowed to hold somebody in custody on criminal matters absent personal service when that's not even an acceptable way to begin a civil lawsuit, quite frankly, is inexcusable. He has 3 years. Yes, he's been on warrant status for 3 years, but it's also 3 years that he's obviously stayed out of trouble because no one found him, no one picked him up, he wasn't pulled over. So given and it's clear that he forgot about this. You know, if the court will recall, I mean, 22 was a little past COVID, but you know, we're talking a time period when the court itself was somewhat lacking in diligence as far as processing cases. He's stayed out of trouble for these last 3 years. He has no felony history. Given all the and confirmed residence, confirmed employment. Given all that, we ask to be released free trial services.
All right, sir. Looking at everything, I am going to go ahead and release you to the supervision of pretrial services. The information I have is that the warrant carried a $4,000 bond amount. So even if I were to impose a bond, that would have been the highest I would have been willing to go. But given your lack of history, I'm willing to give you a shot on pretrial services. You have to make your court dates. If you don't make them, the warrant's going to issue for your arrest and you're not getting out again. Your next court date will be an arraignment hearing on July the 9th at 1:30 in the afternoon. You will get paperwork with all this information on it before you leave the jail. You're not to possess any alcohol, illegal drugs, firearms, or weapons. You will comply with any directions pretrial services gives you. You are not to have any contact with the alleged victim, their residence, or their workplace. Once again, sir, make sure you make that court date.
Thank you, Your Honor.
You're excused.
And Your Honor, I have received the pretrial services report for Mr. Godoy whenever we're ready to call that matter again.
Okay. For jail, if we could do Mr. Godoy's case after Miss Kemp's, if that's possible.
Yes, Your Honor.
Ma'am, can I get your full name, please?
Victoria Kemp.
All right, ma'am, we are seeing you this evening because you've been arrested on some new felony charges. You've been charged with burglary in the 3rd degree, a couple of counts of that, as well as possession of drug paraphernalia, and that paraphernalia charge is alleged to be a misdemeanor offense. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and I'm appointing the public defender's office to represent you. Now we're going to talk about your release conditions and your next court dates. I've read everything provided to me, and I see that the state is asking for a $2,000 bond. Mr. Raptis?
There's nothing further, Judge.
Mr. Zarzicki?
Largely will defer to the court. I will note that there is absolutely no felony history with the exception of the other charge that she was on release for. She is a lifelong Tucson resident, does have part-time employment as a house cleaner. To the extent that we accept the assertion of the anonymous complaint, these are non-violent charges. Her other charges are not charges as well. We'd ask the court to consider release to pretrial services, given that she was, making some progress on her prior case and failing that. We'd ask for a minimal.
All right, ma'am, I am going to order you be held on a $2,500 cash or secured bond. I do have concerns considering you have that other open case pending. You will be supervised by pretrial services if you post that, and you'll need to comply with any directions they give you. You're not to possess any alcohol, illegal drugs, firearms, or weapons. You're not to have any contact with any alleged victims, their residences or workplaces, or the incident locations. Your next court date will be a preliminary hearing on July the 14th at 1:30 in the afternoon. Ma'am, if you're released, you need to make your court dates. If you don't, then a warrant will issue for your arrest. Do you understand?
Yes.
All right, ma'am, you're excused. Mr. Fisher, we're going to go ahead and go to Mr. Godoy. Thank you for your patience, Mr. Godoy. So we're going to go back on the record. I have the same counsel present, and Mr. Fisher has advised us that he has had an opportunity to receive and review the pretrial services report. So I have looked at everything. State, what's your recommendation in this case?
Judge, the state's recommending a bond amount of $15,000. We do want to highlight the danger to the community. Mr. Godoy, on 3 separate occasions, sold cocaine to an undercover officer, but that's not really what's the main concern. The main concern is during the search warrant that was executed on his house, police recovered 3 handguns, a shotgun, over 1,100 rounds of ammunition, $1,500 in cash, and 0.75 pounds of methamphetamine and 0.153 pounds of heroin, well over any type of threshold, and so indicating that he's at least a mid-level dealer, Judge. So this would, we're highlighting the threat to the community in this case, and we're requesting a $15,000 bond. Thank you.
Mr. Fisher?
Your Honor, we are respectfully requesting that Mr. Godoy be released to pretrial services. He does have prior criminal history, but the pretrial services report did not indicate any prior failures to appear. In fact, things have actually gotten more stable for Mr. Godoy in the community. As he is married, he works full time. He has 5 dependent children that rely on him and his income at this time. He is innocent until proven guilty. I don't have any probable cause for him, so I can't attest to any potential hand-to-hand sales with undercovers. However, what I do know is based on the execution of the search warrant, all of these items were located in a shed on the back end of the property where there's no admission from Mr. Godoy that he's the one who had exclusive access to said building. Also, during these undercover dealings, there was no possession of a firearm during those dealings that at least is uncovered at this time. Therefore, Your Honor, the defense respectfully submits to the court that Mr. Godoy is not a danger to the community, as the firearms and the guns were only located together in the shed and not necessarily, during drug transactions. Also, Mr. Godoy vehemently denies ownership of the firearms. So at this point in time, Your Honor, I think that pretrial services would be appropriate and the least onerous conditions necessary to ensure his appearance. Also, one other point of note, Your Honor, that he is in the process of retaining private counsel for the full case. I plan on meeting with the family tomorrow. So he'll have retained counsel. His family lives here, so he's not going to be a flight risk in this matter. Also, just again, based on the nature, these are all non-violent drug offenses.
All right, sir, based on my review of everything, I am going to order you be held on a $10,000 cash or secured bond. You will be supervised by pretrial services if you post that, and you'll need to comply with any directions they give you. You're not to possess any alcohol, illegal drugs, firearms, or weapons. And your next court date will be a preliminary hearing on July the 14th at 1:30 in the afternoon. Now, sir, if you bond out of custody, you need to make sure you make all of your court dates. If you don't, then a warrant will issue for your arrest. Do you understand?
Yes.
All right, sir, you're excused.
Okay.
And thank you, Mr. Fisher, for calling in. You're excused as well.
Thank you, Your Honor. You have a good night.
Yeah. Hello, can I get your name?
Mercedes.
Give me 1 second, make sure I've got your correct file here. All right, ma'am, we are seeing you because you've got some matters pending in Tucson, or a matter pending in Tucson City Court, but you also were picked up on some new felony charges. And it looks like you also have a case that's pending out of Pima County Justice Court. Now, you do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney. And as we go through your cases, I'll let you know who's getting assigned to which one. So what we're going to do is we're going to start with your felony matter first. And in that case, ma'am, you were charged with possession of a dangerous drug and possession of drug paraphernalia. In that case, I'm going to appoint the public defender's office to represent you. You have an attorney seated beside you if you have any questions this evening. Now, I've reviewed the probable cause information as well as the state's recommendation in the pretrial services report. The state is asking for a $1,500 bond with a steps hearing. Mr. Raptis, anything further?
Nothing further, Judge.
Mr. Zarzicki?
Judge, given that he already has an adult should we'll consider it.
Is your client interested in steps?
Let me ask her about stuff. She is, Your Honor, and let me just verify that she's okay with waiving the time.
And actually, since she's in custody, it's my understanding that if they're in custody, the public defenders is not waiving time, just keeping them on the normal 10 days.
Okay. That works for us.
Okay. So, ma'am, what the parties are telling me is that you may qualify for a diversion program at a Pima County Superior Court. It works with people with addiction issues. And if you qualify for the program and if you complete it, that could result in these felony charges never actually being formally filed. Now, it sounds like that's something you might be interested in, and I see you nodding your head. So what I'm going to do is I'm going to set a steps hearing, and that will be on July the 9th at 9 o'clock in the morning. That will give you a chance to check in with the team, see what the program's about, see if you qualify, and see if it's something you still want to do. I'm also going to set a preliminary hearing on July the 14th at 1:30 in the afternoon. I am going to hold you on an $1,100 cash or secured bond at this point, so you're earning some time credit, and because you have warrants in these other jurisdictions. Now, if you are released, you will be supervised by pretrial services. You're not to possess any alcohol, illegal drugs, firearms, or weapons, and you're not to go back to the incident location. Now, in your justice court case, you were charged with misdemeanor counts of shoplifting and failure to appear. I'm going to appoint Robin Ald to represent you. Your next court date will be tomorrow, July the 3rd at 1 o'clock in the afternoon. I'm going to order that you be held on a $250 cash or secured bond. Similar to your other case, you're not allowed to possess any alcohol or illegal drugs. You're also not to have any contact with the alleged victim or the incident location. So basically the shop where this is alleged to have happened, you can't go back there. Now in your city court matters, you have one case pending from 2024 where you were charged with endangerment, criminal damage, possession of drug paraphernalia, DUI, a couple of counts of DUI actually, and then failures to appear. I am going to appoint the City Public Defender's Office to represent you. In addition to the other rights that I mentioned to you, you do have the right to be present for all court proceedings. However, if you fail to come to court, then a warrant will issue for your arrest, and those hearings can happen without you. Now, if you are convicted and you cannot be sentenced within 90 days because of your failure to come to court, then you could also lose your right to a direct appeal. Now, ma'am, it looks like I actually saw you back in October for this case, and at that time I released you on your own promise to appear. But this time, ma'am, I am going to order you be held on a $500 cash or secured bond. You need to make your court dates. These are not going to go away. You understand? Okay, I see you nodding. You are not to possess or consume any alcohol or illegal drugs. You are not to drive without a valid license. Have no contact with any alleged victims or the incident locations. So in this case, I'm going to set a hearing for you on July the 11th at 1:45 in the afternoon. That will be with Judge Bond over at Tucson City Court. If you are released from custody in all of your cases, then your next court date will be August the 5th, 2025 at 9 o'clock in the morning. Now, ma'am, if you're released, stay in touch with your attorney, stay in touch with pretrial. Go ahead and get these handled, all right? All right, you're excused. Did I put that she has the APO hold? Thank you. And the felony one too. And the JP hold. All three. Thanks. Hello, sir. Can I get your name? All right, sir. We are seeing you this evening because you've been arrested on a felony charge of criminal damage. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and I'm appointing the Public Defender's Office to represent you. Now we're going to talk about your release conditions and your next court dates. I've read everything presented to me, including the pretrial services report, as well as the probable cause information. Mr. Raptis, I got your recommendation sheet, and it said you were going to ask for a bond, but it did not have the amount.
Oh, I apologize, Judge. What is the last name of this matter?
Hensley?
Hey,
Oh, okay. I apologize for that, Judge. Oh, I apologize, Judge. I am seeing that mistake now. The state's recommending a $5,000 bond in this case. Oh, I'm sorry. I misread that, Judge. I apologize. Let me just have 1 minute.
Absolutely.
Your Honor, the state's recommending a a $1,000 bond in this case. We will know that there is a substantial amount of damage done to a solar covered parking canopy. It's in the tens of thousands of dollars. He also damaged a U-Haul truck in the same incident. So the state would recommend a $1,000 bond. Thank you.
Mr. Zarzicki?
Judge, I'll note a couple of things. So first off, as far as the, oh, sorry, 1 second. Pretrial services report went down when I was talking. Let me address the damage in this case. I do think there is some issue here as far as establishing probable cause. He has, yes, per the probable cause statement, he was operating a U-Haul and he collided with a canopy. The problem with that is that it sounds like a car accident. And anybody that's been in Tucson long enough sees the number of people that destroy overpasses and destroy things because and these are professional truck drivers we're talking about. Seems to happen on a couple times a year basis. Here's somebody that's an amateur that's ever operating a U-Haul, hit it against a solar canopy. There's absolutely no demonstration that there was criminal recklessness, that he was impaired, that he wasn't paying attention, anything like that. So I don't think there's probable cause here to establish the criminal damage. If the court does determine there's probable cause, beyond that, there's no reason to hold him. He's 3 on both scales. He has absolutely no felony criminal history. He returned the U-Haul truck. He did leave the scene, which, probably doesn't bode well, but that's a misdemeanor. So given that at best we're dealing with misdemeanor charges in this case, given his complete lack of criminal history, given his confirmed housing, we would ask that he be used to pretrial services.
Mr. Raptis, anything as to probable cause?
Judge, so ARS 28-662 does require that a person who's involved in an accident or yet remain at the scene until or shall immediately return to the scene, so that they can provide their information to people who may want to make some sort of claims on it. And the defendant in this case clearly did not do so. So there's clearly they can tie the U-Haul truck back to the defendant, and the damage to the U-Haul truck is captured on surveillance footage. So there's probable cause in this case. Thank you.
Judge, I'll note that without, hold on, let me just check this real quick. I believe, what statute are you referring to, Peter?
28-662.
Yeah, hold on 1 second. Your Honor, I will note that what's required is that he remain at the scene until he has fulfilled the requirements of 28-663. If this is a accident that occurs on private property after hours, which would seem to be based on the security footage, what we're talking about here, then there's nothing he can do to comply at that particular moment with 28-663. There's nobody he can exchange insurance information with. There's nothing else he can do. And furthermore, I'll point out again, yes, to the extent that the court may determine there's enough there for that, that's not what the interim complaint is. The interim complaint is for felony criminal damage. This is not a felony case.
Judge, I would just add there that I think we've all seen situations where people can leave a note. Okay, people regularly leave notes when they back into somebody's car and there's nobody there. This is not a particularly complicated thing that the defendant was supposed to do in this case.
All right, thank you both for your arguments. Here's where I'm at on it. I do agree that absolutely it's very easy to leave a note. However, what somebody does after the accident doesn't necessarily prove that the action leading up to the accident is reckless or fits the mens rea that I need for criminal damage. Can I make that assumption? Certainly. Is it reasonable given the information I have right now? Not quite. So what I'm going to do is I am going to find that there is no probable cause. However, based on my reading of the rule, the case is not getting dismissed. The only remedy is that he would be released on his own recognizance at this point. So what I'm going to do sir, is I am going to release you on your promise to appear. Your next court date is going to be July the 22nd at 1:30 in the afternoon. Now, just because I'm releasing you on your promise to appear does not mean that I cannot also impose release conditions. First off, you are not to drive without a valid license. You're not to possess or consume any alcohol or illegal drugs, and you're not to possess any firearms or weapons. If I didn't mention it already, the Public Defender's Office is appointed to represent you. Now, sir, you need to make sure that you make your court dates and stay in touch with your attorney. If you fail to come to court, then a warrant will issue for your arrest. Do you understand?
Yes, ma'am. Thank you, Your Honor.
All right, sir, you're excused. Hello, ma'am. Give me 1 second. Can I get your name, please?
Larissa Montano.
All right, ma'am, we are seeing you this evening because you have a case pending in Tucson City Court. You also have some new felony charges. Now, we're going to talk about your release conditions and your next court dates. Now, in your felony case, you were charged with possession of a dangerous drug and possession of drug paraphernalia. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and I'm appointing the Public Defender's Office to represent you. Now, I've read everything presented to me. Mr. Raptis, what's the state's recommendation?
Judge, the state recommends a $500 bond. We will note that this is an offense where Ms. Montano is effectively just contacted at a park, and she has a tutor and a small amount of methamphetamine on her person. Thank you.
And again, going back to the theme of having technical difficulties this evening, were you also recommending steps? I see that it's indicated in the pretrial services workup.
Yes, Judge, we are recommending steps.
Mr. Sarzuki?
Judge, given the steps recommendation and given the lack of felony history in this case, we'd ask the court to consider release self-services.
Would your client be willing to waive time?
She waived. Okay, background.
All right, ma'am. So what the parties are telling me is that you might qualify for a drug diversion program through Pima County Superior Court. It's known as STEPS, and it specializes in helping people with addiction issues. Now, if you qualify and if you complete the program, it can result in these felony charges never being formally filed. I see you're nodding your head. Is that something you're interested in?
Yeah.
All right, ma'am. So I'm going to set a STEPS hearing for July the 9th at 9 o'clock in the morning. I'm also setting a preliminary hearing for August 19th at 1:30 in the afternoon. I will note the time is waived for the STEPS process. Ma'am, I am releasing you to pretrial services on this case. You will have to comply with any monitoring or treatment directions they give you, and you're not to possess any alcohol, illegal drugs, firearms, or weapons, and you're not to return to the incident locations. Now, you do have a city court matter. And in that case, you were charged with possession of drug paraphernalia as well as the failure to appear. In addition to the rights I mentioned before, you have the right to be present for all court proceedings. Are you still awake, ma'am?
Yes.
You have the right to come to court for all of your hearings. However, if you don't come to court, then a warrant will issue for your arrest and those hearings will happen without you. Additionally, if you cannot be sentenced within 90 days because of your failure to come to court, you could also lose your right to a direct appeal. I'm going to release you on your promise to appear. Your next court date will be July the 30th, and that will be at 9 o'clock in the morning. Now, ma'am, once again, make sure you make your court dates. If you fail to come to court, then a warrant will issue for your arrest. Do you understand?
Okay.
All right, ma'am, you're excused.
Judge, real quick, I'm going to hand her a card given that she's, I think, having some nodding issues. When was her next court date for her STEPS case?
Her STEPS case, let me open that up real quick.
Apologize.
Her STEPS hearing is July the 9th at 9 o'clock. Her preliminary hearing is August 19th at 1:30. And her city court case is July 30th at 9.
I did get the city court. I appreciate it, Your Honor.
Okay, can I stay here?
Huh?
Can I stay here?
You getting They actually mentioned she would rather stay in custody.
Okay. Mr. Raptis, did you wish to be heard?
Nothing further, Judge.
All right, so what I'm going to do then is I will change it from ROR in this case to a $500 cash or secured bond. I will also appoint the city public defenders. And let me go back on the record in the felony case as well. Mr. Zarzicki, I'm assuming you want me to put a bond in place so she gets some time credit.
Yes, and just the nominal bond in case she does change her mind, because obviously given the steps nature, the sooner she can get out of treatment, the better she's going to be.
All right, so in the felony matter, I will change my previous order in order that you be held on the recommended $500 cash or secured bond. So ma'am, since you're in custody, what will happen is the jail will go ahead and take care of bringing you to all your court dates. Mr. Zarzicki, I am also going to change the preliminary hearing back to July the 14th since she's in custody. So ma'am, since you're in custody, the jail will take you to your hearings as long as you are still in custody. If you're out of custody, my same warning applies. You need to get to court or a warrant will issue. Do you understand?
Okay.
All right, ma'am, you're excused. We're good? Okay. Hello, sir.
Hello,
Can I
John.
get some in?
Yes, ma'am. Your Honor, it's Roman Soriano.
Okay. Give me 1 second here.
Sure.
All right, sir, we are seeing you this evening because you have a couple of new felony cases out of Pima County Superior Court. In one of the cases, you were charged with burglary in the 3rd degree, theft as a class 1 misdemeanor, as well as criminal damage as a misdemeanor. And in the other case, you were charged with 2 counts of burglary in the 3rd degree, 1 count of felony 3 theft, as well as a misdemeanor criminal damage. Now, you do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and I'm appointing the public defender's office to represent you. Now, I have read everything provided to me. Mr. Raptis, what's the state's recommendation?
Your Honor, the state's recommending a $6,000 bond in this case. We will note that there were repeated incidents. These are both victim cases, and both victim cases, and they're both burglaries. As a result, Mr. Soriano is facing mandatory prison time if he's convicted.
Mr. Zarzicki?
Judge, I will note in this case that Mr. Soriano's criminal history, with the exception of an assault on a corrections employee while he was in custody, dating from his last felony before that he has nearly 10 years he has not committed any new charges. Both of the incidents in this case are completely not involved in nature. They're families of unoccupied. I believe both were. One was business, one was a VA. Obviously, we dispute all of those charges themselves. And in fact, on one of them, it looks like the only evidence is a discarded water bottle that had his TNO on it, which I don't mean to minimize, is definitely enough to establish probable cause. But I think does go to the de minimis nature of his participation in these offenses and the fact that there was no real threat here. We'd ask the court to consider whatever bond is imposed to either be concurrent or to consider the fact that he does have these 2 burglaries pending. We'd ask for the court to release pretrial services, and if not, for a combined bond in the neighborhood of $3,000.
All right, sir, I am going to order you be held on a $5,000 concurrent bond between both cases. You will be supervised by pretrial services if you post that, and that bond will be cash or secured. You will need to comply with any directions pretrial services gives you. You are not to possess any alcohol, illegal drugs, firearms, or weapons, have no contact with any alleged victims, any alleged victim residences, or incident locations. You will have a preliminary hearing set for July the 14th at 1:30 in the afternoon. Now, sir, if you're released from custody, you need to make sure you make all of your court dates. If you don't, then a warrant will issue for your arrest. Do you understand?
Understood, ma'am.
All right, sir, you're excused.
Yep, thank you.
Hello, sir. Can I get your name?
Nicholas Romero.
All right, sir, we are seeing you this evening because you've got, let's see, let's double check here. It looks like you have a couple of cases, new felony cases pending. I'm just pulling up your pretrial services report here real quick. So you have been charged with theft of means of transportation, as well as possession of narcotic drugs, possession of dangerous drug, and possession of drug paraphernalia. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney. And I'm going to appoint the public defender's office to represent you. Give me 1 second. I'm having an issue here with some of my paperwork. I want to make sure it's correct. All right, state, what's your recommendation?
Your Honor, the state is recommending a bond amount of $2,500. We will note that Mr. Romero was pulled over in a U-Haul today that he was supposed to have returned approximately 10 days earlier. He's found with some paraphernalia in the car. We will note that there are approximately 500 M30 pills also confiscated, which is a substantial amount, well above a personal amount, personal amount use, personal amount. But we make that $2,500 bond recommendation for Mr. Romero. Thank you.
Mr. Tarticki?
Judge, given that he has a probation hold, we largely will defer to the court, but we'll ask for a de minimis bond on this.
I'm on probation.
Huh?
I'm not on probation.
You do. Yes, you do.
For what?
You are on probation. Looks like he should have been terminated. I'm not sure why pretrial services is showing a felony probation status on him. In that case, I would like to amend my prior argument. In that case, we would ask for a release to pretrial services. I'm going to point out that he did successfully, it looks like per the records, he did successfully complete his last probation stint. There is, yes, there was a alleged overkeeping of a U-Haul, but the U-Haul was eventually returned. There's no
contact with U-Haul, and they give me.
And he indicates that he was in contact with them. He did have the rental agreement to show to deputies when he got stopped. As to the state's contention that 500 pills is well beyond personal use for M30s, I mean, no, frankly, it's not. Given the potency and addiction levels that we've been dealing with counterfeit M30s, it's not uncommon. 50 plus, it's a daily use. So given that, I do think this quite likely could be well within personal possession. Again, I'm assuming that's true, which they dispute all the allegations here. Given the nonviolent nature of this offense, given the fact that he did successfully complete probation on his most recent offense, and given that at least as some tolerable argument as far as the issues with the taking of the U-Haul, we'd ask the court to consider release to pretrial services. Beyond that, the state's recommendation of a $2,500 bond, the court deadline is
All right, sir, I am going to order that you be held on a $2,500 cash or secured bond. You will be supervised by pretrial services if you post that, and you will need to comply with any treatment directions that are given. Now, I believe that I appointed the public defender's office office to represent the co-defendant in this matter, so I'm going to appoint the legal defender's office to represent you, sir. If I mentioned something different, that's going to be a revision to my order. Your next court date will be a preliminary hearing on July the 14th at 1:30 in the afternoon. You will need to comply with any directions pretrial services gives you. You are not to possess any alcohol, illegal drugs, firearms, or weapons, have no contact with any alleged victims, their residences, or their workplaces. And part of the reason that I'm doing this, sir, is I do see a history of violations of probation, and while your most recent probation term was terminated, it was terminated with what looks like a jail sanction of quite some time. Now, sir, if you're released from custody, you need to make sure you make your court dates. If you don't, then a warrant will issue for your arrest. Do you understand?
Yes, Your Honor.
All right, sir, you're excused. So, what's up? Sir, can I get your name?
Jonathan Wilbur.
All right, sir, we are seeing you this evening because you've been arrested on new felony charges. You've been charged with domestic violence, aggravated assault by strangulation, as well as aggravated assault with a deadly weapon or dangerous instrument. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and I'm appointing the public defender's office to represent you. You have counsel seated beside you if you have any questions this evening. We're going to talk about your release conditions and your next court dates. I've reviewed everything presented to me. Mr. Raptis, did you wish to be heard?
Yes, Judge. We're recommending that Mr. Wilbur be held on a $20,000 bond. This case does involve intimate partner strangulation. There's a high lethality risk associated with this type of offense. Further, Judge, the victim did report to police after they arrived to the scene that when Mr. Wilbur was strangling her, that she felt that she was close to losing consciousness. She also stated that he pointed a handgun at her. Mr. Wilbur did confirm that he does in fact have a handgun. The victim sustained various injuries, not the least of which, Judge, are bruising to her neck, which is also consistent with her claim of being strangled. We do have some contact with the victim. She stated that she does not want contact with Mr. Wilbur, and we'd ask the court impose that as a condition of his release, if he's released. Thank you.
Mr. Zarzicki?
Judge, in this particular case, first off, I want to point out that Mr. Wilbur has no prior felony history. Yes, he was assessed with an NBCA flag, likely because of the allegation of strangulation. Almost always that's going to trigger an NBCA flag in these cases. But otherwise, his new criminal activity score was a 2, his failure to appear score was a 3, so relatively low numbers on those. I will note that there is some indication of injuries here, although obviously that does not establish how they happened. It also does not establish that there is a strangulation per se. That's largely based on her statements to police, which we fully contest. If we would ask for release to pretrial services if the court was inclined to hold him, given his lack of felony history, given his and the nature of his scores in this case, 20,000 does seem excessive, well beyond what Mr. Wilbur can afford to post. Also, plenty of jobs. He also would like to indicate that he does have 2 jobs, steady employment. You know, he has been a Tucson resident for 20 years now, and he has injuries on himself from her. So that at very least there was some degree of mutual combat here. With all that in mind, like I said, we'd ask for release to pretrial services, and failing that, something as far as the bond goes, that he actually has some potentiality of posting something on the realm of 5,000 to 10,000.
All right, sir, based on my review of all this information, and I do understand that the allegations are just that, allegations at this point, I still do have some concerns for the community and particularly for the victim. I am holding you on a $20,000 cash or secured bond. You will be supervised by pretrial services if you post that, and you'll need to comply with any directions they give you. You're not to commit any acts of domestic violence, possess no alcohol, illegal drugs, firearms, or weapons. Most importantly, sir, you are not to have any contact whatsoever with Victoria Laredo, and no contact means no contact, nothing third party, nothing electronic, nothing in person, no telephone calls, no social media, no contact. Your next court date will be a preliminary hearing on July the 14th at 1:30 in the afternoon. Sir, if you're released from custody, you need to make your court dates. If you don't, then a warrant will issue for your arrest. Do you understand?
1 second here. So you can ask your attorney to furnish. So give your attorney I Jeremy. And then that can I know that Jeremy will do the man. I answered. He had questions about potential modification.
Understood. You're excused, sir.
What's the guy looking with it? What's the guy who's like that?
Hello, can I get your name?
Laura Zavala, Your Honor.
Great, ma'am. We are seeing you this evening because you have a few different matters pending. You've got some new felony charges, and you also have warrants out of Pima County Superior Court as well as Marana Municipal Court. So we're going to start with the new felony case first. You do have in that case, you've been charged with unlawful flight from a law enforcement vehicle. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney. And I'm going to appoint the public defender's office to represent you. Now I've read everything presented to me. State, what's your recommendation?
Judge, for Ms. Zavala's new case, we're recommending a $500 bond.
Mr. Thursicki?
Judge, I would note, while I do appreciate the state's recommendation on the bond as well as the warrant amount being 500, I would ask for release to pretrial services in this case. Again, not to beat a dead horse, but this is another case where it was a mailed summons. She indicated that she did not know that she was the court date and was not aware of the warrant. She does have confirmed housing with her father. She does have some employment as a part-time housekeeper. And given the nature of these charges as the non-violent nature and largely drug-related nature of these charges, and her previously being out pending summons and a lack of any criminal history since 2017, would ask the court to consider release to pretrial.
All right, so in this case, and this is largely because I'm seeing an outstanding warrant in a separate jurisdiction as well, which makes it a little bit more difficult for me to give somebody the benefit of the doubt as to just missing a court date. So ma'am, I am going to order you be held on a $500 cash or secured bond. In this case, you will be supervised by pretrial services if you post that, and you'll need to comply with any treatment or other directions they give you. You're not to drive without a valid license, possess no alcohol, illegal drugs, firearms, or weapons, and your next court date will be a preliminary hearing on July the 14th at 1:30 in the afternoon. Now, go ahead.
And Your Honor, if not, just for the record, she did want to indicate that she was supposed to start a new job. That's a very court's determination.
It's actually an old job that I just got back, and I'm supposed to start it tomorrow. So I was asking for pretrial releases, but if not, I understand.
Okay. Given that I have multiple cases pending with warrants in another jurisdiction, I'm not going to be able to release you tonight. It is a $500 cash or secured bond. So if you're able to post that, then you can go from there. So in your other felony matter, you were charged with possession of drug paraphernalia as well as another unlawful flight from law enforcement.
Wait, I'm sorry. I have two? I didn't even know I had one.
Well, ma'am, the one we just talked about was actually a new charge. And now we're talking about a case where on April 2nd of 2025 in a separate case. Now, in this separate case, you were again charged with unlawful flight from law enforcement vehicle as well as possession of drug paraphernalia. Mr. Raptis, any recommendation? Oh, you're muted, Mr. Raptis.
Apologies, Judge. On the warrant case, the state's recommending a bond of $1,000. Judge, and we do believe that the conduct itself of this offense, the failing to fleeing from law enforcement, is kind of indicative of her willingness to comply with orders in general, and so the state believes a $1,000 bond is appropriate for the warrant case. Thank you.
Mr. Thursicki?
Judge, given all of the things that not to beat a dead horse, but that already stated in the prior argument, in that she is already being held on the other case, we would ask for the court to consider a $500 bond.
So I will do another $500 cash or secured bond. It will be consecutive with the same release conditions as the other case. I'm setting an arraignment hearing for July the 9th at 1:30 in the afternoon. Now, in the Marana matter, you were originally charged with possession of drug paraphernalia as well as a failure to appear. And in that case, it looks like a warrant was issued back in January of this year. In that matter, ma'am, I'm going to order you be held on a $50 cash bond. I am going to appoint Janet Altschuler to represent you. Or sorry, not Janet Altschuler. Yes, it will be Janet Altschuler. Your next court date will be a case management conference on July the 3rd at 12 o'clock in the afternoon. Now, ma'am, if you're released from custody, you need to make all of your court dates. If you don't, then warrants will issue for your arrest. That's all for this evening, ma'am. You're excused.
Thank you.
Hello, can I get your name?
Martin Alvin Shot.
All right, sir, we are seeing you this evening because you've been picked up on a warrant for a felony case where you were charged with possession of burglary tools as well as burglary in the 3rd degree. It looks like the warrant was issued in May of 2025. Now, sir, you do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and I'm appointing the public defender's office to represent you. We're going to talk about your release conditions and your next court dates. I've read everything provided to me. Mr. Raptis, what's the state's recommendation?
Judge, the state's requesting a $2,500 bond. The pretrial services report does indicate that he's failed to Mr. Shack has failed to abide by his previously set conditions of release while when he was under pretrial services supervision. So continued release to pretrial services doesn't seem appropriate. Thank you.
Mr. Zarzycki?
Judge, we would ask that he be given another chance at pretrial services. The further report, his own admissions to pretrial services that he forgot about. It does appear that he did not abide by them. However, that being said, he was initially given a chance on pretrial services. He did not pick up any new charges. He has no prior felonies. And this is a fully non-violent case that he's charged with. So with all that considered, we'd ask the court to consider release pretrial services, barring that, we'll defer that bond.
All right, sir, I am going to order you be held on an $1,100 cash with secured bond. You will be supervised by pretrial services if you post that, and you'll need to comply with any directions they give you. You're not to possess any alcohol, illegal drugs, firearms, or weapons. You are not to have any contact with any alleged victims, their residences, or their workplaces. I'm setting an arraignment hearing for July the 9th at 1:30 in the afternoon. Now, sir, you need to make sure you make your court dates if you bond out of custody. If you don't, then a warrant will issue for your arrest. Do you understand?
Yes, ma'am.
All right, sir, you're excused. All right, everyone, I think that's everything on our calendar. Thank you for hanging in there with everything. Have a good night.
Thank you, Judge.